Shall we start? Good evening to all of you. Today we are dealing with a new topic, Guardian and Wards Act 1890. Before we go into the subject, we must know why this enactment was passed. Say, mostly the unfortunate minors, if the parents purchase the property in the name of their child or in the name of the son or daughter, whomsoever it may be, what if this father or mother are given unfettered authority to sell and alienate the property? What would happen is tomorrow, if everything is alienated, the security of the minor is affected. So that is the reason why the Guardian and Wards Act has been passed and has been enacted. And the scope of the Guardian and Wards Act is that any person who wants to get appointed as a guardian of the person of the minor or the property of the minor has to apply to the court in a particular form and covered by the Guardian and Wards Act. First and foremost, you must remember is there are three people who are supposed to be darlings of equity. One is a minor, another is a person of unsound mind, and another is a person who is an idiot. Their interests are the married woman also, and their interests will have to be safeguarded at any cost by the courts. And that's the reason why the Guardian and Wards Act of 1890 was passed. The guardian and wards itself means guardian means the person who has to take care, the person who is entitled to the custody, the person who has to look after the minor, the person who has to look after the interests of the minor, his health, other needs, education, etc., etc. So, for that purpose, this Guardian and Wards Act has been enacted. And the scope of Guardian and Wards Act is whenever you want to get a guardian or a custodian or a manager or an administrator, be it the father, be it the mother, be it the grandfather, be it the grandmother, on the paternal side or the maternal side, they will have to apply to the court under the provisions of the Guardian and Wards Act. And first and foremost criteria that has to be satisfied is the paramount interest of the minor has to be safeguarded. If it is not going to be safeguarded, what would happen is the minor will be left on the crossroads of penury, that is poverty and starvation. So, to prevent such scenarios arising, this Guardian and Wards Act has been enacted. Sometimes what happens is both the father and mother die, and then the child is left an orphan. But there are numerous properties in the name of the child. At least for the sake of property, someone on the paternal side or someone on the maternal side would come forward to act as the guardian of the unfortunate minor. But please remember, sometimes human greed, human avarice is to such an extent, what would happen is if unfettered power is been given to the guardians to alienate the minor's property, then what would happen is the minor will have nothing when he comes of age, his education will not be met, his medical expenses will not be met, and other needs will not be met. So that is the reason the Guardian and Wards Act has provided certain safeguards through which a person can act as a guardian as far as the minor is concerned. At the initial stage, or at the threshold, I like to tell you, as far as Hindus are concerned, the because ours is a patriarchal society, mostly tilted towards the father. The question is, father is the natural guardian of a male boy up to the age of 7 years, 5 years, I'm sorry, 5 years, and after that, the mother gets a custody if the father is unfit. The mother gets the custody. As far as the female child is concerned, preference is given to the mother. Why? Because a female child requires so many things. The necessities of a female child is much more than what is for the male child. That is the reason, till the attainment of the age of puberty, that means Pedaman Shaya Varaku, the mother is the natural guardian of the female child. So preference is normally given to the mother as far as guardianship is concerned. As far as female children are concerned, till the age of 7 years, the father remains the guardian in Hindu law, and as far as the female child is concerned, till attainment of the age of puberty, the question is the mother is the natural guardian. In the absence of the father and mother, the question is the preference is given to the grandparents of the child on the father's side first, and if they are not available, then the preference is given to the maternal side, maternal grandfather or maternal grandmother. And sometimes it is also given to the near relative who has got interest to maintain and manage the affairs of the minor concerned. So it is always said in equity, minors, unsound persons, idiot, and the question is, as far as married women are concerned, they are supposed to be the darlings of equity, and their interests are always zealously guarded by the courts, and that is the reason why the Guardian and Wards Act 1890 has been enacted. Please remember, this is a very unique act where there have been no amendments till now for the past 2 centuries. We are in the 2 centuries have passed after this enactment has been enacted. So, Guardian and Wards Act controls the relationship vis-a-vis the minor and the ward concerned. Ward means the child concerned, be it a male or be it a female. So, the scope of the Guardian and Wards Act 1890 is to control the regulations which govern the appointment of guardian or the person to look after the interest and welfare of the minor. And the prime criteria, as far as appointment of a guardian is concerned, is the welfare of the minor. Why these situations arise is because we are living in an artificial world. Because today the females do not care for the males, males do not care for the females, and the child is left in the wilderness. So that is the reason some checks and balances have to be regulated, and the interest of the minor has to be taken into consideration. They shall not be thrown into the dustbin to partake the food morsels of food which is left in the dustbin. That is the reason the Guardian and Wards Act has been enacted. So that is the scope and introduction as far as the Guardian and Wards Act is concerned. The first definition that is given in the section 2 or section 3 of the Guardian and Wards Act is, who is a guardian? Guardian is a person who is appointed by the court, who is nominated by the court under proper procedure to look after the interests of the minor, the welfare of the minor, the property of the minor, the person of the minor, give him proper education and give him proper food or give him proper shelter. So that is the reason the prime interest of the welfare of the minor is entrusted to a person called a guardian. Please don't misunderstand that guardian means only the father and mother. But if both are unfit to be appointed as guardian, then the paternal side grandparents can be appointed as the guardian. So guardian is a person which has been defined as a person who has got the custody of the minor, manages the minor, looks after the welfare of the minor, looks after the person of the minor, and also administers the property standing in the name of the minor. Then, sir, who is a ward? Ward is a person who is below the age of 18 years, who has not even attained the age of majority. Such a person is called a ward. Then, how does a collector come into the play? Suppose, let us say, both the mother and father are unfit to be appointed as guardian. There are no near relatives of the minor. Then, in that case, the collector of the particular district can act as the guardian of the minor concerned with the permission of the court if duly appointed. Then we have also got court of wards. In Urdu, they call it as Sarfakas Mubarak. That means court of wards is an authority which has been created, which takes over all the minor's property, and in case the minor does not have, let us say, guardian or father and mother, the Sarfakas Mubarak or the court of wards looks after the welfare of the minor, administers the property, derives the income out of the property, invests it properly, maintains proper accounts, and also sees that the minor is brought up in life and his welfare is taken care of. That is called Sarfakas Mubarak, or it is called court of wards. And sometimes if the minor does not have guardian or does not have parents, does not have near relatives, then the collector of the district can also request the court to appoint him as a guardian and take care of the minor's person as well as the property. So these are the three. And another thing, competent court. Which is the court? Court normally under the Guardian and Wards Act is the principal district court of that particular place. Only the district court has got jurisdiction to entertain an application as far as appointment of guardian is concerned, and normally the principal court is a principal district judge of the particular district. Here, this is what all is the introduction to the Guardian and Wards Act. Now we go into the proper perspective, that is source of jurisprudence of Court of Wards and chartered High Court. It does not take away the jurisdiction of the Court of Wards substituted by Act of 1937. Court of Wards is what is, I told you also, is a Sarfakas Mubarak, which has the jurisdiction to look after, administer the properties and manage the properties of the minor concerned. But as far as a competent civil court is concerned, or the High Court exercising original jurisdiction is concerned, it does not take away the jurisdiction of the Court of Wards in case the minor has no person to look after, though he has got properties. So, Sarfikas Mubarak, or what is called the Court of Wards, and the court jurisdiction are simultaneous, and the jurisdiction of the Court of Wards or the Sarfikas Mubarak is not taken away by the Guardian and Wards Act. This is what Section 3 says. Then Section 4, sir, where any proceedings are transferred under the section, in any case where a guardian is appointed or declared, the district judge or officer to whom they are transferred shall, for any of the purpose of the act, be declared to have powers. So normally, here Section 4 speaks about where proceedings are transferred under this section, in any case in any case where a guardian is appointed or declared shall, for any of the purpose of this act, be the district judge or officer to whom they are transferred. Normally, under the GNW Act, or what is called Guardian and Wards Act, the principal district court of a particular place is empowered to entertain all applications under the Guardian and Wards Act to appoint a guardian, to remove a guardian, to discharge a guardian, appoint a new guardian, appoint a successor guardian. All these powers are vested with the district court or any officer that is appointed by the government for the particular purpose. This is what Section 4 says. Section 4A says, a Hindu mother is entitled to act as natural guardian of her illegitimate children, may by will appoint a guardian for any of them in respect of the minor's property or person or both. In some extreme cases, suppose a child is born to a lady and it's an illegitimate child. It is outside wedlock, a child is born. In that case, suppose minor has got certain properties, the mother has got the power to appoint a person or apply to the court to appoint a guardian as far as the minor is concerned, look after his properties are concerned, look after the welfare of the minor is concerned. Then the mother is empowered under 4A to ask for appointment of guardian regarding her illegitimate children. Then, sir, we go to Section 5. The court shall not appoint or declare any person to be a guardian against its will. That is, the minor should be given due consideration. Please remember, sometimes what happens is the minor is brought to the court, either by the mother or by the father. Then the child is asked whether you want to remain with your mother or whether you want to remain with your father. And please remember, all children are supposed to be innocent. All children are supposed to have some wisdom or the other. All children are supposed to have some independent thinking of their own. And they know how the father treats them, how the mother treats them, how it will be safe for the child to remain with the mother or remain with the father. The consent or the opinion of the minor is taken before a guardian is appointed. Please remember, though the law says if so-and-so is a natural guardian, it doesn't mean that the interest as the minor has no say. Minor has got definitely a say. Minor will be asked with whom you want to live, whether you want to live with your father or whether you want to live with your mother. Then after the wishes of the child is taken, the guardian is appointed as per law. That's what Section 5 speaks about. Then, sir, Section 6. In the case of a minor, nothing shall be construed to take away or derogate from any power to appoint a guardian. So, as far as the courts are concerned, as far as the minor is concerned, all powers shall be construed to take away or derogate from any power to appoint a guardian. As far as the courts are concerned, it's a prerogative of the court to appoint any person as a guardian, taking into account the welfare of the minor, the interest of the minor, and with whom he will be more safe, where he will be looked after, where he will have proper maintenance, where he will have proper education, who is more competent to look after the minor. And all these considerations will be taken, and the powers of the courts is unlimited. The court can gauge all aspects and then appoint a guardian. Please remember, just because you file a GWOP or what is called Guardian and Wards OP, and you want yourself to be appointed as a guardian, court will not order it immediately. Court will have a regular inquiry, regular evidence is conducted, and the evidences of relations are also taken. How the father is, how the mother is, what is the financial background of the father, what is the financial background of the mother, what are the properties owned by the minor, how their interests will be safeguarded. All these factors will be taken into consideration by the court, and the powers of the court are not reduced in any manner. Court has got wide powers before appointing or declaring a person, be it a man or a woman, as the guardian of the person and property of the minor. Then 7 deals with power of the court to make order, where the court is satisfied that for the welfare of the minor, that an order shall be made appointing a guardian of the person and property. The court may declare a person to be the guardian. An order under this section shall imply to removal of any guardian who has not been appointed by not been appointed by will or other instrument, or appointed or declared by court, and this cannot be done until the powers of the guardian has not ceased. Sometimes what happens is, by a will or a testament, a person is appointed as a guardian to look after the interests of the minor, to look after the person of the minor, to look after the property of the minor, or by any other instrument, so and so is constituted as the guardian till his powers are for 1 year or 2 years or 3 years, whatever it may be. Please remember, the person so appointed under an instrument or under a will may not be in the same state of health always. So that is the reason, till his powers subsist, the court will not interfere in appointing a guardian. But in other cases where the court feels it emergent, court feels it necessary, court feels it expedient, then in that case, a guardian can be appointed under the law. This is what Section 7 says. Then what are the conditions, sir? With Section 8, we shall stop. Section 8 deals with conditions for order. The person desirous of claiming to be the guardian of the minor, or any relative or friend of the minor, the collector of the local area within which the minor resides, on which has been the property is located, the collector having authority in respect of the class to which the minor belongs. Suppose the minor is residing within the periphery of Hyderabad. Then who is the collector, sir? The district collector of Hyderabad. Then in that particular case, here it is said, where now person desirous of being appointed to be the claiming to be the guardian of the minor, or any relative or friend of the minor, the collector of the local area within which the minor resides, on which the property is located, the collector having authority in respect of the class in which the minor belongs. So the opinion of the collector is taken in such circumstances where the application is filed for appointment of guardian either by the parents or by a relative or by a friend of the minor. Then the minor resides within the jurisdiction of a particular district of which a particular person is a collector. Then in that case, the views of the collector will be taken in what interest will be, who is to be appointed as guardian, the fitness of the guardian, the welfare of the minor, the upbringing of the minor, the education of the minor, the financial requirements of the minor. The collector will be asked a question and a query, and on being satisfied that the person has got all the qualifications, a guardian can be appointed under the provisions of Section 8. Then Section 9 deals with the case of a minor, nothing shall be construed to take away or derogate from any power to appoint a guardian of the person or property of the minors. So the court has got unbridled powers to appoint a guardian of the person and property of the minor, and nothing shall take away the powers of the court. The court has got enormous powers. Court can always exercise the discretion. Court can always apply the mind and appoint a guardian, and no fetters are there as far as the exercise of jurisdiction by courts are concerned. That's what Section 9 deals with. With Section 10, we shall try to close, sir. Here, how an application for appointment of guardian is made. The normal format is, first is you say in the court of the principal district judge, Rangareddy district. Then we say GWOP. GW means guardian and what's OP. Guardian and what's OP of whichever year it may be. Then the name of the person who applies to name, son of father's name, age, address, and occupation of the person who applies to be appointed as a guardian of the minor. He will be the petitioner. And the rival claimant who also claims to be the guardian, wants to be the guardian of the minor, his name or her name is given as the respondent number 1. And second one is all concerned. Then down is, in bracket you write, in re the guardianship of the minor, guardianship of the person of the minor so and so, aged so and so, aged so and so, in the custody of the respondent, bracket end. Then we say petition for appointment of guardian of the person and property of the minor so and so under Section 7 and Section 10 of the Guardian and Wards Act. Then we are all in the era of computer typing. First and foremost is the petition above named begs to state as follows. 1. Name, address, and description of the petitioner. Number 2. Name, address, and description of the respondents. 3. Address for service. If you are the advocate, address for service of all notices, and summonses on the petitioner is that of his counsel, so and so, president of so and so, whatever it is. Then next one is address for service of all notices and summons on the respondent is the same as given above in the cause title. Cause title means the above description which you have given. Then the next paragraph will be brief facts of the case. In brief facts of the case, you describe yourself. The petitioner is the natural father of the minor so and so. The petitioner was married to the respondent number 1 through a lawful wedlock on so and so date at so and so place, and a male child by name so and so was born to them on so and so date. The marriage certificate of the petitioner and the respondent number 1 is filed and marked as document number 1, and the date of birth certificate duly attested of the minor child is also filed and marked as document number 2. Then other things is the next, of course I'll come to the rest of the format later. Next one is you say nature. The first is form of application is name of the person, whether male or female, whether first is name, second is whether she is married. Second thing is if the guardianship is required regarding a female child, what you have to mention is whether the female child is still a spinster or she is married, and if she is married, what is the name of her husband, what is the address of the husband, when they were married, all those particulars will have to be given. Please remember, once a female child is married, the father loses his right over the female child, because for all practical purposes, the husband will be her hubby, or husband as you may call it, may be her guardian. So the full particulars will have to be given. And then next one is person having custody description. Suppose, let us say, the custody of the child is with your wife, that is the respondent. So you'll have to say the child is at present residing with his mother in house number so and so, located at so and so place. Then next requirement which you have to furnish is near relatives. Near relatives is relatives on your husband's side and relatives on the wife's side, and also the remote relatives who are connected with the family. And next requirement is whether a guardian has been appointed by any person. So the next particular which you have to mention is whether any guardian has been appointed as far as the minor is concerned, either by a will or by any other instrument. Those particulars will have to be given. Then previous application with result, whether any application has been made prior to this, or whether it is pending in any court, or if so, if it's filed, what is the result of that when it has been disposed of. Those particulars will have to be mentioned. The next one is qualification of the guardian and grounds. Next one is you'll have to say what are your qualifications. You will have to say, as a petitioner, you are the husband. You say, I'm employed in so and so software company, Wipro or so and so. I'm getting I'm getting a monthly salary of so and so, so and so. I've got a property. I've got 3 or 4 properties. I am the fit person to be appointed as a guardian as far as the minor is concerned. The grounds on which you seek your appointment as guardian is, you say the relations between me and the respondent number 1 has got estranged, and we are living separately under separate roofs, and we have got separated from each other for the past 3 or 4 years, and there's no cohabitation as far as we are concerned. But as far as the qualification of the wife is concerned, she is also decently employed, and she is employed in a software company and drawing a salary of nearly 2 lakhs per month. And she is also qualified, and she holds a MCA degree as far as her qualifications are concerned. Then, sir, next one is if addressed by collector, it shall be by registered post to the court. Suppose, let us say, the collector himself files an application to be appointed as a guardian. Then, in that case, a collector shall send the copy of the application by registered post, acknowledgement due, to the honorable court, and the court will, under registered post and acknowledgement due, and then he gets the acknowledgement that his application to be appointed as the guardian of the person or the minor is concerned has been accepted. Of course, not decided. Then next one is declaration and willingness to act as guardian with 2 witnesses. Here, please remember the 10th requirement is declaration and willingness to act as guardian. If you see the rules, circular orders, and the civil rules of practice, there is one rule called form number 2. In form number 2, declaration and willingness to act as guardian. That is it's compulsory that this document has to be filed. How do you word it, sir? I so and so, so and so, so and so, son of so and so, so and so, so and so, and father of the minor concerned, do hereby declare that I intend to get appointed as I'm willing to act as the guardian of the person and property of the minor. If so, this court appoints me as so. I will discharge all my duties faithfully and diligently and with prudence. And then he signs, and 2 witnesses will have to attest that willingness declaration. And this is absolutely mandatory. It has to be filed along with the petition for appointment of guardian. Then the next section, sir, if section 11. Once the petition for appointment of guardian is filed, the Shirasadar or the CMO of the court checks up the application, whether it is in order, all the particulars have been mentioned, and it is fit in all respects. All the ingredients which are required are duly filled up as required under section 10 of the Act. Then the Shirasadar puts up a note to the judge, and the judge says the OP may be numbered. Then the OP is numbered, and it is taken up by the same court or allotted to an additional district judge to be disposed of according to law, and a date will be fixed for appearance of the opposite side. And then once the counter is filed by the other side, the matter is heard threadbare, and evidences are laid on both sides, and after hearing arguments on both sides, the court decides the matter accordingly. I think section 12 deals with court may having custody to hear any person. This section 12 deals with what is called temporary custody. Section 12 says Any person who is having the custody of the child will be directed to produce the child into the court, and then suppose on hearing arguments in that interlocutory application which is filed under section 12 for temporary custody of the child, then in that case the court orders the temporary custody of the child till the disposal of the application to the person whom it decides entitled to the custody. So that custody is not permanent; it is temporary. It's something like a temporary custody is given, and then once the application is decided, whoever is entitled to the custody of the child will be given to the opposite party. But under section 12, if you want to ask for a temporary custody, you must file what is called, not in this, you cannot ask in the OP itself. You must file an interlocutory application, ask for interim orders under section 12. What will be your prayer, sir? To direct you'll have to say the child so and so is at present in the custody of my wife, that is respondent number 1, and it is in so and so place. I so and so place, and I am very much attached to the child, and I cannot live without the child. Please direct my wife, that is the respondent number 1, to produce the child into the court, ascertain the wishes of the child, and then grant me temporary custody of the child till such time my OP is decided and I am appointed as a guardian of the person of the minor concerned. So please remember, like any other interim order, you can always take an order under section 12, giving the definite reasons why you want to get the temporary custody of the minor. Then once a petition is filed under section 12, the other side is given an opportunity of filing the counter, and both the parties will be heard. An interim order will be passed directing the respondent number 1, that is the wife, to hand over the temporary custody of the child to the father till the disposal of the application for appointment of guardian. So these are all interim orders. Please don't think that it's going to be permanent. Once after evidences are laid on both sides, after arguments are heard on both sides, then the court passes an order appointing you as a guardian. Then you get permanent custody. But temporarily, you can always file an application to grant temporary custody of the child till the disposal of the OP. But sufficient reasons have to be shown why you want temporary custody. In that case, the woman has no other right, that the respondent has no other alternative than to hand over the child to the custody of her husband. That is, a petitioner who's asked for appointment as a guardian. I think with this section 12, we shall close today. And tomorrow, please remember this Guardian and Wards Act comprises of nearly 50 sections, out of which we have completed 12 sections, and we'll go to the rest of it in the next class, that is tomorrow. Thank you very much. Any questions, please?